Welcome to the Lawn Business Podcast. I'm with James Cushing. James, you can say hello.
How are you doing?
I'm well, thanks. Thanks for calling in. Jim, tell us about your practice. We'll start there.
Thanks. I met Anthony way back in college through a mutual friend, Steve, if you remember.
There's only one mutual friend?
Well, I think we developed many mutual friends through that, I guess. Different people there. And I've been in practice in Philadelphia since 2002. My practice, my office, Faye Reva Cohen, is has a sort of claim to fame as a labor and employment side practice, civil rights type of stuff. But I am sort of been relegated to a lot of domestic, family, divorce, custody support, unemployment comp, small claims sort of thing. I do a lot of landlord tenant and contract stuff too. Sort of the garden variety, everyday, real person type stuff. Usually plaintiff side.
So you're claiming I'm not everyday or real person?
I guess not everyone's patenting things every day, but yeah. Right. So I've been doing that since about 2002 for the same law practice, which sounds crazy to me. Actually, just yesterday was my 12-year anniversary at this office.
Well, congratulations.
Thank you. And, my practice is Faye Reva Cohen at Ability. What's that?
Do you get a pin? Do you get a framed certificate?
I wish I got a gold watch or something, but it was just more of a, hey, good, nice going. Thanks for not asking for more money. I told you. And something like that. And I've been, I've been maintaining a blog, which is, I think, what sort of inspired this cast, but it's judicialsupport.wordpress.com, where I've been writing about some copyright infringement issues, which I guess you'll get to, Anthony.
Yeah, absolutely. I can break those down for you. I've got all the paperwork up here, and what you've been talking about is a case called William Roger Dean against James Cameron, 20th Century Fox, Dune Entertainment, blah 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 blah, and lots of other people who put money behind movies. Who is William Roger Dean?
Roger Dean, he's usually known as Roger Dean. In fact, it wasn't until I've been a big fan of his for years, and it wasn't until I saw this lawsuit that I knew his name was William. But Roger Dean has
stage
been around
names,
for about...
aren't they wonderful?
What's that?
I said stage names. They're wonderful.
That's right, yeah. Well, he goes by his middle name. So Roger Dean, he's been around as an artist, as a surrealist artist for, I would say, 45 years. His claim to fame is doing art for album covers mainly, although he's done some other things on television, movies, and architecture. But his main I think art avenue is going to be album covers for rock bands. So he's been the primary artist for the band Yes, the progressive rock band Yes. He's done their logo and many album covers for them and their stage set designs. But he's also done... What's that?
I was going to say you're a big Yes fan.
I'm a huge Yes fan.
You're allowed to admit this here.
Right. And I was going to say that nowadays in 2014, there's very few small Yes fans anymore. It's people who've been carrying the flame for a long time. And I've been sort of obsessive about him for a long time. Much to my wife's chagrin, I've seen him 20 times, and and met some of the guys and gone to festivals and stuff. So, yeah, nowadays, Yes fans, it's sort of like Star Trek fans, where we have our own conventions and festivals, and we all know each other.
It's kind of like Bruce Springsteen fans, like Bruce Springsteen fans can recite the 38 times that they've seen Bruce Springsteen to the day at the hour.
Yeah, that's right. It's very similar, right?
Set list down. Right.
So yeah, and I would say Yes fans, but also the genre of progressive rock is like that. It's a very somewhat small community anymore. And so he did Yes covers. He did in the '80s. He did Asia covers, the band Supergroup Asia, some Uriah Heep, Gentle Giant, other groups. And so he has a very distinct style with the sort of floating islands and surrealist sort of architecture, art, landscapes and so on. And I think his work has been done in movies before, but he's never really taken action. I'm sure you're familiar with the movie Galaxy Quest.
Of course.
Yeah, right. There's a scene in that movie where they all go into a star base that looks like a rock formation in the shape of like a teardrop. I don't know if you ever remember that scene.
Not
but that was a direct.
But that's okay. You
right.
keep going.
There's a picture. I think that picture is linked on my blog somewhere in one of those things about Roger Dean. But anyway, so that was ripped right off of Yes Songs, which is a live album for Yes. But Roger Dean didn't sue over that because it was one minor scene. But I think when he saw James Cameron's movie Avatar, he saw that movie and sort of said, "Well, this whole movie is my artwork," and I think that inspired the lawsuit. Because I've met Roger Dean several times. He doesn't know me. Don't get me wrong, but I've met him because there used to be this thing called the Northeastern Art Rock Festival. That was an annual thing for about 12, 13 years in Lehigh County, Pennsylvania, that I went to every single year practically, and he was almost always the artist in residence. So every year I'd come in with my truckload of stuff for him to sign. And he graciously did. And he sold me some artwork, which is now hanging in my law office right
Excellent.
now. So
Your
I
wife
asked,
wouldn't allow that at home, would she? That has to hang.
What's that?
Your wife wouldn't.
No,
allow
yeah, the spare artwork is sort of lodged somewhere in an attic somewhere, but the rest of it is here in my office. And so I talked to him about his artwork being used in media, and I think Avatar is what he said. That was just too much for him to take, I think.
I hear you well. By the way, as an aside, did you know that Phil Hartman started as a record album cover designer?
From Saturday Night Live?
Yeah.
No, I had no idea.
His most famous one is the Crosby, Stills, Nash cover with the Celtic knot.
I had no idea. Now I'm in front of a computer, so I'm going to Google that and just make sure.
You're allowed. You're absolutely allowed. I'm in front of the computer too. So, so Roger Dean sued James Cameron, 20th Century Fox, and basically all the companies that put money into Avatar. And his basic theory, or his lawyer's basic theory, because let's be honest, this isn't his theory.
Right.
Jim and I both know. We tell our clients what the legal theory is. The clients don't make it up themselves. And by the way, I'm sure Jim understands those who do make it up themselves are generally pretty wrong. But
that's exactly right. I mean, there's a reason why we studied the law, right? I mean,
in this particular case, what you said, I think, comes through in the complaint and in then the amended complaint. Roger Dean had to amend his complaint in this particular suit. And the overall theory is that he is suing because this planet in the movie Avatar looked a lot like his paintings. And that's really what he was going at, that there were... I had it right up here. I'm trying to... I had it up and now I've lost it. But talking about floating islands, talking about the mountains, the arches, what the trees look like, and from that particular... What'd you say?
There's a dragon in there, too.
Okay. And so the thinking is that... And there are pictures, and I don't know that we can... maybe I can link to these pictures somehow when I post this, but...
Anthony, one of my blog posts, I think you've got it. I have a series of pictures of them comparing right next to each other.
Okay.
Of the movie and Dean stuff.
Sure, I have that. I have it up because it's in the final order of the case. So I see a floating mountain and I see floating trees and I see a lot of that as well. And I see the dragons as well. And in this particular case, the theory is that I did floating mountains, I did dragons, I did trees, and I'm looking at this movie that says floating mountains, floating trees, dragons, and it's got to be from my, has to be infringing upon my particular copyright. And I can certainly, from an artist standpoint, see that. The one thing that thought that just popped into my mind. It reminds me a little bit, but I'll show you why it's not quite analogous later on, to the George Harrison suit. Are you familiar with the George Harrison copyright infringement suit from the 70s?
I don't think so, but maybe.
Okay, so
I just IM'd you some photos on your Facebook, by the way.
Perfect, thank you. And George Harrison was sued by the copyright holder at the time of a song called "He's So Fine," and it was for My Sweet Lord. And at the time, George Harrison's lawyers argued this got to the Supreme Court. George Harrison's lawyers argued, well, he grew up in the 50s. This song probably was on the radio when he grew up. I shouldn't say grew up in the 50s, but he was listening, obviously, to the radio in the 50s. He was performing in the 50s. This song, He's So Fine, was popular then, and he probably heard it. And at that point, he didn't know he was copying. And the Supreme Court basically said that that's not, your mental state is not really a reason to avoid copyright infringement. In this particular case, they lined up the chords, they lined up the structure, they lined up the melody, and and musicologist after musicologist, and of course, expert witnesses are paid by each side to say what they, to say what they are saying in court. So there is always a little distrust of an expert witness, but still, the expert witnesses lined everything up and said, look at how similar it is. It has to, because of the chord structure, because of the melody, because of the harmony, it's so much like the original song that he copied. So I'm sure
the opposing expert said, I don't know what you're talking about. These two things cannot be more dissimilar.
Of course.
Yeah.
But here, in this particular case, the Supreme Court said there's no mental aspect of copyright law. You either copy it or you don't. And whether or not you meant to copy something doesn't excuse you from infringing upon somebody else's copyright. And so we have this amorphous idea in copyright law. And it's something that a lot of people come up to me and ask me about. Do you need 10%? Do you need 5%? What point is there copyright infringement? And we have another series of cases that the Supreme Court kind of shrugs their shoulders and says, every case is different. It's based upon facts, and I don't know. And isn't that lovely, the Supreme Court saying, I don't know?
Well, it doesn't give us a whole lot of guidance, I guess.
No, and so we don't have a lot of guidance. There are times when an infinite amount of use of a senior work is acceptable, and there are times when an infinitesimal amount of a senior work is not acceptable. So it's about the originality. It's about if something else is used. It's about mental state, and we kind of take all this and we put it in a blender. In this,
in their defense, though, how do you put into words or quantify similarity in a piece of artwork, for example? How do you do that besides saying, "Oh, I know it when I see it"? To quote another famous Supreme Court phrase.
Well, since that particular phrase isn't going to work its way in here, thankfully, but the idea in copyright law and the court's final decision, because the court dismissed this case, hits the nail on the head, which is that there are ideas and there are expressions of ideas. And the idea itself, and I think this is probably where the pleading really did lack, even in the amended pleading. The pleading really talks about things like the floating mountains, the floating trees, the dragons. And it really gave the court a lot of leeway to come out and say, well, floating mountains are not all that original. And it allowed the court to say a tree that's growing up in the sky is not all that original. So you're able to take this idea. So an idea itself is not protectable, and that we know. It's the expression of the idea. And so the question is does the expression, does this, as the court says, mise en scène of Avatar, take from the original work? And
maybe you could help explain the difference between idea and expression. So if I were an artist and I came up with the idea of, arches coming out of a ceiling or floating in the sky, that's my idea. So, but that I can't copyright that, is what you're saying.
Well, exactly. When you have this particular idea, you can take it and put it on a medium, and I don't care if the medium's a computer file, a canvas, a piece of paper, or your wall. And there's an expression that can fall under copyright law.
Because I think most people would put more value on. Maybe that's where the confusion lies in all the responses I've seen on the Yes websites to this. Like, it was his idea.
Sure, it certainly was his idea to take a mountain and have it floating in there. However, the other issue is who else is making this, and this was something that the court also discusses. The court discusses, works that are similar to Roger Dean's works, and that it's really the ability to show that this floating island is similar to, the plaintiff's floating island, for example. So you'd have to show that the colors are the same. You'd have to, and ultimately the court is saying that you have to plead this, that you have to plead that the colors are the same, that the angle's the same, that the overall look is taken from the original work. And the court's basically saying there are so many ideas of things like dinosaurs on a prehistoric island far from mainland, far from the mainland. I mean, that's nothing new, and that can be found in many fantasy stories. So that's really where the court is breaking it down and showing the difference between, okay, you have a dragon, and these guys have a dragon, but how can you say that this particular dragon design is taken from your design when we have dragon designs all throughout history?
So what then becomes of the value of the copyright? If it's that specific design, then the copyright seems to be extremely narrow.
Sometimes it is, and I think that's part of, I would say, the flexibility of copyright law. On one hand, we're protecting art. So somebody creates a visual work, and we're able to protect it. And if somebody creates something new, like maybe a new robot, or maybe there's something special about a dragon, I don't know what would be special about a dragon in today's world also, because we've seen dragons with wings, dragons without wings, dragons that fly, dragons that don't. I don't know, a three-horned dragon, is that going to be special enough? I don't really know. I think we've seen a dragon that looks like Sean Connery in a terrible fantasy movie. But it's hard to say what's going to make something special. Maybe it's a special robot design. There's something that I think maybe we can be very flexible about, because we've seen robots that look human, robots that don't look human. We can talk about Rosie from the Jetsons. We can talk about your typical 50s sci-fi robot. We can talk about the Terminator, or Terminator 2. We can talk about how something mechanical looks, and what those particular differences are. So from that standpoint, I think the look is the expression. Whereas for settings in a fantasy world, we're probably, not looking at stuff that's all that original in its expression. And that's really something. Like, for example, the court here says stone arches in most of the plaintiff's artworks are relatively smooth and set in barren land or seascapes. And so we're looking at stuff that's not, we're looking at stuff that I think we've seen before. But then it actually makes the comparison. Stuff in Avatar is jagged, uneven, overgrowth with trees and moss. And set in a photo...
Anthony, you went in and out there a couple times there.
Okay, sorry about that. I'm just saying...
I missed the last, 2 minutes.
Sure, not a problem. But really, what I was saying is that the particular ideas themselves are not all that protectable, unlike if we're trying to look at robots. But then what the court does, the court decides to drill down a little bit and say, all right, so all you did was you pleaded that your ideas are copied and not your particular expression. And then the court said, let me look at your expression. And when the court looked at the actual expression, the court found plenty of differences. For example, the stone arches in the plaintiff's artworks are smooth, whereas in the movie Avatar, it's jagged and uneven. And, any of the trees found on plaintiff's artwork doesn't look like the trees in Avatar. So they took the drilling down at least one level to say, look, even if you're to sit there and replead this again, the court didn't see any way of showing that the expressions are similar. So the key here, I think, in copyright law is that the idea is, again, not necessarily protectable. It's about the expression. And then if you're going into court, you really need to sit there and in your pleadings discuss the expressions and how they're similar.
Now, I saw in the first complaint there were many more defendants and many more claims, but most of those sort of fell by the wayside when he amended it. I guess that the copyright was the strongest of the weak claims that he had.
I think that's an accurate statement.
Yeah,
absolutely. I think that's accurate.
Now, I don't know if this is directly relevant, but is there a time when you can protect an idea? I mean, is that a concept in intellectual property? At some point you have an idea that this thing is my idea, and I want to keep this, sort of like a patent or something.
Well, patents protect an invention, and while I know that we've probably read plenty of ridiculous stories about patents that have been granted, if you're not able to make a prototype, at the very least, then a patent isn't going to be protecting too much. Even though I haven't touched patent law in many years, that certainly is still a key to patent law. You have to be able to, it's an invention, so you have to be able to make it. In this particular instance with your question, I would say the answer is no. Now, I will say that contract law is probably going to help you here. So if you have an idea, like maybe a new business idea or a new process for creating something, if there's something there that's nebulous, that doesn't fit any other kind of intellectual property law, if you're going to disclose it to other people, I'd say your best bet there is to get a non-disclosure agreement, because that confidentiality is going to help you treat it as what we call a trade secret. So you have to set up that confidentiality, but more importantly, actually, than setting up the confidentiality, is setting up how it's a secret. So whether it's something that's password protected on one computer, or it's sitting in a safe, or only 2 people know about it, and there are high penalties for disclosing it. If there's an idea that can't be substantiated otherwise, then I would say that's how you have to do it. You really have to do it as a trade secret, but you start it by contract and making parties agree to behavior to not disclose the secret.
Now, I saw in the judge's opinion, I mean, I don't practice copyright law, so I'm sort of reading it as a semi-intelligent person. But I was looking at it. He made some comment about Roger Dean presenting evidence of people's impressions of the movie as evidence that there was ideas stolen, but then the judge didn't seem to think that was particularly persuasive. Because I will tell you that, you know, when the movie came out, when I was at prog rock festivals and the various websites I peruse and Facebook pages I look at, I mean, there was a chorus of Yes fans saying, "Oh, this is clearly ripping off Roger Dean. This is, this is a huge injustice to the prog rock community," or whatever. But the judge doesn't seem to think that other people's impressions of the work are of that dispositive.
Yeah, I'm not really surprised that the judge shrugged that off. It's to me, well, one, from an evidentiary standpoint, it feels a little like hearsay to me. So I don't know that it would be necessarily admitted unless there was some kind of scientific poll of Yes fans that were taken. Does that make any sense to you?
Yeah, I mean,
okay.
Right. I mean, so you can't have random people's opinions as evidence. I mean. Exactly,
and so I think that's one particular issue. But from another standpoint, if the judge is looking at the pleadings and then looks at the evidence and has already made up his or her mind, I don't know what your experience is, but my experience is that when it comes to intellectual property, a lot of judges have made up their minds pretty quickly and don't really look at everything particularly. But I find with intellectual property law, not that cases are more simple, because I think the concepts are more foreign to people who don't work in intellectual property all the time. But sometimes it's maybe a wish to get a complex case out of here. If I can be a little cynical about going into the courtroom.
Well, I don't think that's altogether inaccurate. The judges often try to find the path of least resistance of deciding a case.
And I think here it's really self-serving, to have a bunch of fans say, "Well, of course it's ripped off," and I'm not surprised that a judge would just kind of ignore that. I probably would too, and I probably wouldn't have ever mentioned it, to be honest with you. But
there's a certain amount of confirmation bias, right? I guess.
Yeah, exactly. But I'll tell you, I was in federal court earlier this year on a trademark infringement suit, and sitting in mediation to hopefully settle the case, the magistrate judge says to me, "It's not that I find your motion to dismiss frivolous, but I really don't like it." And I don't really think that you guys have a defense here.
Well, at least he's honest and straightforward, right?
He was very honest and straightforward. Exactly correct. I was in Look, I'm in mediation to settle a case. That's why I agreed to mediation, because I figured that settling the case. Believe it or not, the plaintiff did not want to mediate. The plaintiff wanted to keep plugging forward, and I insisted in a, not a letter to the judge, but in a required pre-hearing filing, that mediation would be proper and it would help settle the case. And sitting in the first hearing, the judge says, "Mr. Verna," I stand up, "Yes, Your Honor. You look like a person who would like to settle this case." I said, "Yes, Your Honor, I would." Good. We're going to have mediation.
What a coincidence.
What'd you say?
So what a coincidence. That is exactly the kind of person I am.
Exactly. So I'm not surprised, getting back to your question, that the judge kind of shrugged it aside for various reasons, whether it's legal or practical or cynical,
Right. I mean, unfortunately, when you have sometimes in that situation, I'm assuming that the judge is doing you something of a favor, saying, I don't know how far this will go in trial, but let's see if we can avoid needless litigation by mediation. And sometimes the clients don't necessarily appreciate that favor they're doing you, as opposed to just dismissing your claim outright, right?
Well, I wasn't out to. How can I say this without without giving away anything that might be confidential? I wasn't being a bulldog just to be a bulldog. I did it thinking that there would be a chance of having the plaintiff file new pleadings in this particular case. But ultimately, if it's going to cost you X to settle the case, and it's going to cost you 20X or 40X to to take this all the way, well, why wouldn't you just pay X? And
sure.
And that's kind of the thinking that I had, was that I wanted to try to get into the mediation. That was really my goal from the beginning with that particular case. And so we settled. But if we had to litigate, I was going to do it with a motion to dismiss. It's the key with, and this was something that one case that my partner discovered in writing that motion to dismiss was a case by Judge Sweet, I believe is his name, and he still is sitting in the Southern District of New York. And at this point, he's in his 80s, so he's in that judicial part-time program. And he talks about when you in intellectual property, you really need to discuss the plaintiff's intellectual property, the defendant's intellectual property, the infringement, the similarities, and the harm. And you need to link it all together. And
right.
You really need to be complete about it. And that's going to be true regardless if you're in a patent case, a trademark case, a copyright case, or some other form of intellectual property. You really need to discuss yours, theirs, the copying, the harm, and the damages. And you gotta link it all together. And I think in this particular case, getting back to the reason why we're talking here, the pleadings don't necessarily do that. And if you're in a copyright infringement case, I really think you need to say, here's the plaintiff's work, here's the defendant's work, and here's where the similarities lie. And another case that just popped into my head that I remember reading years ago, although I haven't picked it up in a long time, is one that was filed against George Lucas, but I forget if at the time it was LucasArts or Lucasfilm. And it was against the producers of the original Battlestar Galactica, and talking about the similarities between Star Wars and Battlestar Galactica. And the court, in its final opinion, because it went to a federal appeals court, I think it was the Ninth Circuit in California, and in it, that's exactly how the court wrote its opinion. Here are all the similarities. And it went 1, 2, 3, 4, and it just listed them all. And it got from the general to the specific. And so I think in dealing with intellectual property lawsuits, that's where the beginning has to lie. tie everything together and be as specific as you can in the complaint. That might sound, for people who practice law, that might sound maybe a little too specific in your pleadings when you file the complaint in the lawsuit, but I think that's really good advice.
Well, I wonder in this case, presuming that Roger Dean, he's somewhat of a celebrity, so I'm sure he can afford a decent lawyer, and I wonder if they did the best they could with the material that they had, right? I mean, you can't turn a pleading into something you don't have, right? So
I agree with you. And
what you're saying, at least it seems like what you're saying is that even the court, gave him the benefit of the doubt and actually did look at the pictures and compared them for him and said, even if you were to amend this complaint, you could not amend it in such a way that would even lead to a cognizable case as it is.
Absolutely.
Because I guess the alternative oftentimes for motions to dismiss or summary judgment is that the court will say, and maybe I don't know if this is like this always in copyright, but it's certainly in civil law where the court will sometimes say, you wrote a pretty bad complaint here, but there's nuggets of something in there you could turn into something, so we'll let you have an opportunity to amend it one more time because you might be able to turn it into something. And the judge seemed to say in this case, there's no sense in that because no matter what you do, there's still nothing here.
I agree with you.
Work with. Yeah,
I agree with you.
So
I was just trying to think of getting to the bigger ideas here, but I do agree.
Yeah,
I do agree with you on that.
Although, it seems sort of obvious that part of the job of the attorney is to connect dots, right? The dots are out there, and I think part of our job is to say, here's how you get from point A, which is what I believe to be something that damaged me, to point B, which is this is how much it damaged me, to point C, and now it's this person's fault or whatever it is. It's part of our job is to link those things together in a story that's sensible and cognizable in some way, generally speaking. So I think in this case, you're saying, the complaint that Roger Dean filed was somewhat deficient in one of those ways, and perhaps he couldn't have been. I don't know if he could have done it better or not, but that's the way it was.
Well, they already filed their amendment as well, so. You mean,
what they mean? After the motion to dismiss was done?
Well, they filed their complaint and then they filed an amended complaint.
Oh, right, yeah.
Yeah, so they already had their second chance, and I'm never in state court, and certainly you and I are licensed in radically different states. So I don't ever sit in state court, so I'm not too familiar with how it feels in state court, but in federal court, I will tell you, if you don't get it right the second time, you're out the door.
Yeah, I'm not sure. State courts, at least in Pennsylvania, it's a little different. I mean, it all depends on whether an answer was filed and whether a summary judgment was filed and so on. But, if in Pennsylvania, at least, if someone files a complaint in the state court and the defendant files preliminary objections, you can file an amended complaint. I've done it several times. And at some point, the defendant can simply file to request the final form of the complaint because you can't do that. You can't have that dance forever.
Exactly.
Right? Where you?
Exactly. Yeah. I will never forget my first time in federal court here in the Southern District of New York, where Judge Berman looked at both sides and said, "This is America. Everybody gets a motion to dismiss, but if you're going to be amending." This is your second time, so if the motion to dismiss is granted, you're out the door. So, because the party was voluntarily amending. So, he basically said, when you file that amendment, that's it. You're getting you've given up the right for them to complain. It's already your second chance. If they're still right, you're out the door. So, federal court, I will say, what I've liked about my federal court practice is that it's no nonsense. As opposed to what I hear from my New Jersey colleagues. My New York colleagues, I think I hear a lot of no nonsense, except for the people who do criminal law, where all I hear about is motions and filings and delays and all sorts of fun stuff.
Well, I do family work, so it's all nonsense. Practically. Motion practice and pleadings is a secondary to, whether you can make someone cry, I guess. But, being an adult for when adults cannot be adults.
I'm going to keep my mouth shut on that particular comment.
Yeah, right.
Anyway, Jim, I hope that I was able to shed some light on this particular case, and I know you've got work to do, I've got work to do, so I don't want to take up more of your time.
I appreciate the opportunity to discuss it. It's yes, there's always something I like to talk about, and Argentine art is pretty close.
I've noticed that.
Yeah. So onwards and upwards, and we'll see.
All right, Jim. Sounds good. You have a wonderful afternoon. And how can people get in touch with you if they want?
Oh, just so we know, Roger Dean has another 25 or whatever days to appeal this. So this might not be the end of the story.
Yeah, obviously that's his choice if he would like to appeal or not, and I'm sure he has enough money to do that, so I wouldn't be all that surprised. I'm not too sure that it would be all that successful, so maybe he won't. I don't know. But it doesn't, to me, it doesn't feel like it's all that egregious of a decision, to be honest with you. But
no,
yeah,
right, but like he's there, he's probably has enough money in retainer to file a notice and at least give it a go, right? I mean, there's no sense in that.
Absolutely. And certainly what circuit court you get to go to, and in this particular case you're going from New York to the Second Circuit, may influence that particular decision. The Second Circuit is a highly regarded circuit with judges that handle complex intellectual property all the time. I'm sure you're familiar with the Christian Louboutin, trademark case with the red soles, and whether or not it's, that's an acceptable trademark or not. And it's sitting in the Second Circuit, and it's something that my partner and I argue about often because I say it should be a valid trademark and she disagrees. But anyway, the Second Circuit is known for handling complex intellectual property. So maybe the lawyers are saying, hey, let's go for it. So yeah, there's still plenty of time to appeal.
Right. To answer your question, how to find me, as you said at the beginning, my name is James W. Cushing, although my friends call me Jim, and you can email me at jwc@fayrivacohen.com or find me at www.fayrivacohen.com. It's FAYERIVACOHEN.com. And, of course, I keep a blog where I talk about Roger Dean, yes, and law and other sorts of stuff. At Judicial Support. That's right. At judicialsupport.wordpress.com. And if he files an appeal, that will be on my blog. So be on the lookout.
All righty, sir. Thanks very much for coming. And I know that everybody listening knows I'm Anthony Verna. I'm a partner at Kravitz and Verna PLLC, and you can reach me either at kravitzverna.com, spell it like Lenny Kravitz since we're on the musical theme, or you could reach me at vernalaw.com. Thanks very much.
Thanks, Anthony.
Talk to you later, Jim.
All right, see you, bye.